Hi, Antonia Mercorella here, CEO of the REIQ. Thank you for joining us today. As you would be aware, on the 23rd of May, the Queensland Government passed the Residential Tenancies and Rooming Accommodation and Other Legislation Amendment Bill. This bill, of course, creates the Stage 2 rental law reforms that we have been waiting for. Today, that bill was assented to, and so I want to speak about those Stage 2 rental law reforms, which will commence today, and I will also touch on some further provisions that will commence at a later date that is yet to be determined. So let's start with the laws that start today. First of all, rent. Let's look at the topic of rent. Now, it's important to understand that from today's date, it will be unlawful to accept rent that is any greater than the advertised price. We know that it's always been unlawful in Queensland to solicit or ask for more rent, but as of today, it will also be unlawful if a tenant offers a greater amount to accept that amount. So that's really important to understand. In addition to that, rent in advance. Now, there were some 11th hour amendments to this rent in advance provision, so I'll take you through it because it is slightly complicated. The first part is this. When a residential tenancy is advertised or offered, it will not be lawful for a property owner or a property manager to accept an offer for rent in advance that is greater than 1 month in the case of a general tenancy agreement, or greater than 2 weeks in the case of a periodic tenancy or a movable dwelling. Having said that, we did manage to get a victory for both tenants and property managers alike. It will be possible to accept rent in advance during a tenancy that is greater than those limited amounts, only, however, if a tenant offers that. So it's not lawful to ask, but certainly if a tenant indicates during the tenancy they'd like to pay rent in advance, it will be acceptable and lawful to allow that to occur. Now, of course, one of the most fundamental and significant changes that will start today relate to frequency limits. And what this law will do as of today is that those new laws that started last year, limiting the amount of times that rent could be increased to once every 12 months, those laws will attach to the property and not to the tenancy agreement. And what that means in practice is that even if a brand new owner owns that property, they will still be bound by that rule, and similarly, even if there is a new tenant. Now, it's important to understand the way that these new laws work. And in a moment, I'll talk about the retrospectivity element. So I want to be really clear. We're getting lots of questions about this. What about if the tenant was on mates rates? What about if the tenant was on very low rent for a variety of reasons? What about if it was an NRAS property? What about if the new owner conducts a series of repairs and adds a lot of value? But the law will be clear. That rent limit will apply irrespective. What it will also mean is if a new owner comes along, cannot increase the rent, even if it's a brand new tenant, for another 12 months from the last date that the rent was increased on that property. Because as I say, those laws, those limits attach to the property, not to the tenancy agreement itself. And I just want to, before we leave this topic, touch on the way that these laws work retrospectively, which is going to be quite as follows. Even if a property settled, for example, a month ago, and of course it was before these laws had commenced, if that new owner from tomorrow wishes to rent that property out, or even from today wishes to rent that property out, if it has been previously rented out, they will not be able to put the rent on that property at a dollar amount that is any greater than the previous rent, and they will be limited to that for 12 months. So in other words, they'll have to go back it had been previously rented out, determine what that rent was and when it was last increased, and they will not be able to increase the rent any further from 12 months. So they will need to wait for 12 months to lapse. Now, as you can appreciate, that of the way those changes will work, we will have to also amend the REIQ contract to make a provision that allows for the disclosure of the rent and when the rent was last increased. And I'll say more about that in a moment. Just very quickly, I'll touch on a few other changes that commence today. First of all, there'll be a new ground for entry relating to smoke alarms. This will give property owners and property managers a new ground for entry if they wish to enter the premises in order to install, maintain or replace smoke alarms. We welcome this. We know that smoke alarms are incredibly important when it comes to saving lives. I think that's a very beneficial change for tenants and property managers and property owners alike. There'll also be some new confidentiality provisions that violence, so an expansion of those DFV provisions that have previously been enacted. And also there will be 3 new head of power provisions. These relate to a portable bond scheme, the introduction of a code of conduct, and also modifications to rental properties for accessibility, security and safety. Now, I just want to be clear that they are only head of power provisions. So they will be, there will be a framework there, if you like. The Act will make a provision for those things, and we would anticipate that the actual specific laws around that won't be made for some time yet, but we will keep you posted on that front. And of course, as you can imagine, whenever we see new laws enacted, there will be hefty penalties that apply for non-compliance, up to $7,000. So we want to ensure that as your peak body, we are keeping you compliant. It's incredibly important that you inform yourselves, educate yourselves about these new laws, and understand what is required required of you, rather, as real estate practitioners. Now, that's a great segue to some resources and educational material. We are, of course, in the throes of a statewide roadshow. I'll talk more about that at the end of the video, but we are putting the finishing touches on an incredibly comprehensive tenancy toolkit. Now, I want to be clear, this toolkit is restricted to members only. It is something we have produced specifically for members. As a peak body, we do a range of education for the entire profession, but I'd like to really emphasize here that we have spent many, many hours working on that resource, and we've also spent significant amounts of money consulting with our lawyers to settle those documents. So it's been it's been an expensive process for us, and we hope you respect the fact that that toolkit is reserved for members. We appreciate that everyone would like to get their hands on it. That's really easy to do. You can become a member today. Not only does that get you access to that toolkit, it gets you access as many times as you like to our property management support service. So I'd really encourage you, if you're watching this, if you haven't thought about this before, please become a member. We'd love your support. Your membership dollars is what allows us to do what we do, to keep advocating for the real estate profession and providing tools and resources for you. If you are a member and you're watching, we understand that you may be asked to pass that toolkit on. Can we ask you to please respect the fact that that is our intellectual property? It is not to be passed on, and we'd really ask you to respect that and not pass it on. And if you are asked for it, please help us and encourage those property managers to become a member of the REIQ, just the way that you are. We are also putting together 31 new documents in RealWorks, lots of new documentation. There'll be a new Form 18A and a range of other checklists, letters, correspondence to clients and tenants, lots of useful information and letters and communication tools that RealWorks uses. And I would expect to see those 31 new documents hitting will works later today. We are furiously working on that. And of course, in the coming days, hopefully tomorrow or as soon as possible, we'll be releasing the new REIQ contract. And that contract will be amended to create a disclosure relating to rent, and it will also contain a number of new provisions that relate to seller warranties around the disclosure of rent and when that rent was last amended or increased, because of course that incoming owner will need that information so that they can comply in the future. By also saying that there will be a range of other new provisions that will come into effect at a later date. These will come into law upon proclamation or become effective upon proclamation. Can't quite get that out today. To run through a few of what these are. The key one, of course, relates to tenancy application processes. We are anticipating that government will put out a prescribed document, meaning that all tenancy applications will use and rely on that one form. And similarly, there will be a prescriptive list of questions and documentation you can ask of applicants when they apply for a rental property. And the Department of Housing has assured us that we will have a hand in the design of that document. And of course, we will ensure we will endeavour to ensure that document reflects the types of questions that you need to ask and the information that you need in order to conduct due diligence at an appropriate level. There'll also be some changes that relate to grounds for entry and notice periods for entry. And of course, there'll also be a series of changes to the type of information, personal information you can collect, for what purpose you can collect it, how long you can store it for, and of course, other things like the destruction of of those documents and personal information. So there is more to come, but we will deliver more education and say more about those additional changes at a later date when we know more about those changes and when we know that they will become law. But for today, we really wanted to highlight all of those key changes that commence today. Now, I mentioned earlier on that we are running a roadshow talking about this. That's a very comprehensive roadshow. It is open to members and non-members alike. And what we are doing during that session is taking you through these new laws in great detail. We are taking you through a series of practical scenarios. We have gathered up a range of FAQs that we'll be taking you through, and we'll also highlight to you all of the tools and resources that are available to you to help you navigate your way through these reforms so that you can be compliant. So that roadshow is running. It started 2 days ago and it finishes on the 21st of June. And we still have places available at our Toowoomba, Brisbane, Rockhampton, Bundaberg and Fraser Coast session. So if you'd like more information about that roadshow, please go to reiq.com/events and you'll be able to find more, or otherwise just give the friendly team at the REIQ a call. And of course, finally, it would be remiss of me not to mention, we've got no doubt. So remember, the team here who run the Property Management Support Service, we are ready to take your call or answer your email. So if you're a member, please make sure you give the team a call if you have any questions at all relating to these new rental laws or any aspect of residential tenancies laws more generally. Thank you for watching. Please share this video far and wide with your property management colleagues and, of course, your tenants and clients as well, if you wish. And we look forward to seeing you at that roadshow. Take care and we'll